what has stood out to me the most is the fact that we have been able to tell our stories, and we've been able to tell the world this is the reality of climate change and this is why they need to act. And it's so significant because we have not been seeing the proportional action, the requisite action that's needed by the world to address this. So we're here at the world's highest court.
No one can act with impunity.
These are crimes that are beyond the pale.
We are talking about human beings. We're not talking about numbers.
We need a court. That's as simple as that.
This is Asymmetrical Haircuts, your international justice podcast with Janet Anderson and Stephanie van den Berg. This episode was produced in partnership with justiceinfo.net.
All rise.
Hi, Steph.
Hi, Janet.
So, the really big one is coming in a few days. It's the International Court of Justice, which so often these days provides moments of high drama for us. It's going to do an advisory opinion on climate change.
And while we'll certainly need to see a lot of commentary afterwards, and we might also ourselves be talking about this case for years later, because it's not every day that a court gets to hear from around 100 states and organizations providing their interpretation of the rules of what states should do about climate change. Really, everybody has a bit of skin in the game, so we'll be talking about this for a long time.
But we thought that beforehand it might be useful if we kind of laid out the big picture, partly because you were there, and we'll come back to that, Steph, and get a sense of the atmosphere. But first, let's talk about who's been arguing what and how it came about. So should we start with what the court was asked? I mean, typical Stephopedia?
Yeah, well, you assume that I know these questions by heart. I had to look them up. In very shorthand, the UN General Assembly asked the court for an advisory opinion in 2023, and they had two main questions. What are the obligations of states under international law to ensure climate protection, and what are the legal consequences of these obligations if they are found? And that question is kind of split in two. They were asked about legal consequences with respect to other states, in particular small island developing states, which bear the brunt of climate change but are not really any of the big contributors. And it also asked about the legal consequences for peoples and individuals, so peoples affected by climate change, and that is then they're looking at things like reparations and money for mitigation of climate change in those for those people.
So if you want to get some more insight into how exactly that question was formulated and why, you can check out a previous pod that we did with Margarita Wawrinka-Singh, who is one of Vanuatu's lawyers. And also, if you want to think about the politics alongside us, we did a podcast with Ralph Regan-Vanu about why Vanuatu chose this particular route of the UN General Assembly advisory opinion question.
And this was such a big case and such an interesting case that it also came by in our more general podcast about climate change activists, and that included Pacific Island students who are really the ones who pushed this idea forward and came up with this idea to get states to kind of prompt the UN General Assembly to ask this advisory opinion.
And since you were there, Steph, and I'm sure that you can remember in absolute terrible detail, why don't you just give us an outline? What were the states arguing? I mean, was it all about this issue of what their obligations are? It was all very highly legal. What was it like?
There was basically a general divide between westernized industrialized states, who are some of the big emitters and also producers of greenhouse gases, which cause or exacerbate climate change, and then developing nations, the global south and Pacific Island states. And the arguments kind of went two ways. The industrialized western states had usually a very legal explanation of obligations, and their general argument was, we have these UN climate agreements. In the event that we have any obligations, we are fulfilling them with this United Nations Framework Convention on Climate Change, and we are doing this. And the global south and these small island nations were much more, that the big emitters should do more, and that they should also compensate these poor countries who essentially bear the brunt of climate change. And there are islands like Tuvalu and Vanuatu in the Pacific that if the ocean levels keep rising, they might disappear altogether. So they have a much bigger stake, and they were arguing that the UN system is all kind of voluntary and there's no very strict limits, and countries don't really fulfill these obligations.
And of course, we're going to get into the substance of what was actually argued. But again, just, there we are in The Hague, and we want to highlight the extraordinary nature of the fact that this kind of discussion was going on at all. I mean, again, how on earth did we get here?
Well, as I just hinted at briefly before, this took a very kind of odd route to get here. As a lot of people who listen to our earlier podcast knows, there was a group of 20 plus students from the University of South Pacific who came themselves from 8 different Pacific Island countries, who came up with this idea in kind of like a workshop situation where they would go and lobby with states around the world via the UN General Assembly to ask the court about these legal obligations of states.
One of the people that we've spoken to previously was Vishal Prashad from Fiji. We had him on the podcast before, and you also caught up with him again, Steph, just after the hearings?
Yeah, I was really curious to see what he would think of actually being there in the Great Hall of Justice and seeing this case come to fruition, because he was one of the people that was in that classroom so many years ago thinking about this idea, and here it was. Everything that he worked for was actually happening.
It has been very emotional, honestly, to be back in the ICJ. We never thought about the emotions and what you do in a moment when you're back here, but it's just been crazy to experience all of this in a really emotional roller coaster. I think what has stood out to me the most is the fact that we have been able to tell our stories, and we've been able to tell the world this is the reality of climate change and this is why they need to act. And it's so significant because we have not been seeing the proportional action, the requisite action that's needed by the world to address this. So we're here at the world's highest court. And I think what we've seen throughout the world, throughout the 2 weeks, has been arguments from both sides, really. The countries that are on facing the most significant effects of climate change argue for climate justice, human rights, future generations, and on the other hand, the minority of countries, the large polluting countries, those that hold the burden of the historical responsibility for causing this crisis, come out time and time again throughout the 2 weeks to find creative legal ways to shirk their responsibility, move out, try to evade, that's the word I used in my speech today, evade their responsibility and obligations, but not just that, their consequences, the responsibility that flows out of their inaction. So I think it's been a week that was very enlightening for us, but I hope it was also for the world, because in very clear terms, the world also heard through these hearings the real intentions behind countries. That's not masked in rhetoric, that's not masked, that doesn't happen behind the closed doors of negotiation rooms, but is in open court. You've heard what countries say, what their positions are, comparing it to what they say out elsewhere on how they want to be climate champions.
At the hearing, there were a lot of people who spoke, and I tried to grab some of them after, and so you'll hear also a bit of noise of the court in the background. But another super interesting person I met was Brenda Reson Sapuro, who is an environmental lawyer and a really passionate advocate for social and environmental justice. She's also an advocate of the High Court of Kenya, and she is a coordinator for the World Youth for Climate Justice, and she spoke on behalf of the youth of Africa in the hearings, and she spoke on behalf of the youth of Africa, the Caribbean, and the Pacific under the Organizations of African, Caribbean, and Pacific States in the hearings themselves.
Well, first of all, just to say that I stood there on behalf of the youth of Africa, Caribbean, and Pacific under the Organization of African, Caribbean, and Pacific States. I would say, first of all, that I'm extremely humbled by that opportunity, because it is something that is historic. These proceedings are historic, and the fact that I got to stand at the Great Hall and speak does not mean that I'm the greatest or the most deserving, but it is an opportunity that I'm extremely grateful for, and I thank Christelle for believing in me and allowing me to represent the youth. In terms of the nerves, well, this is a big case. That's a big court, and it's only normal to get nervous. But when you know there's something that must be done for change to happen, then somehow the nerves go away, because something had to be done and someone had to speak. In this case, the grace fell upon me, and therefore I had to match up to their expectations and deliver to the best of my ability.
And what's the most important message that you want judges to take away from what you told them? What do you really want them to remember from your speech?
That our hope is in them. I think, we've had people saying from the very beginning that when the young students conceptualized this advisory opinion, it was for a solution to come from the court, and we have no other place to go to. So we are looking upon them. We are hoping that they will be the ones who will put an end to this threat to humanity, threat to communities like mine, threat to states that have already lost a great portion of their territory. So maybe just to say that hope and the fact that we rely on them.
Another thing, I know we're going to get into the substance, I promise you, but I was also conscious while I was watching what you were up to of how much media attention there was this. There weren't just journalists like yourselves, but also a ton of film crews. It felt like everybody and their mothers were there at the ICJ.
Yeah, we usually, like today, I was at a hearing for the ICJ, which was about Equatorial Guinea and France, and there's like 5 people in the press room. This was just packed to the gills. There were people roaming the halls of the ICJ. There were overflow press rooms. There were so many people doing stand-ups outside. We never really see it. But it was also interesting to see that there were all these documentary filmmakers and people looking at the longer route of this. And in that respect, we also want to point ahead to a documentary that is being made. It's called The $1 Trillion Case, and it's being made about bringing this case to the ICJ and what it means to the people in the Pacific.
Yeah, our colleague Valentina Petrucci went to have a chat to the director of that documentary, Felix Golenko, when he was in The Hague for the Movies That Matter festival. That was earlier this year. And she was asking him how he responded to it all as a documentary maker.
I had the feeling these young people from the South Pacific, they really knew what they're talking about. And I was inspired how brave they are and how keen they are about what they're doing. And I thought a documentary is a chance to transport something like that. So yes, it's about this court case, it's about this initiative, but also maybe even more important that it's about the people behind all of that. Beyond the proceedings and the outcome of it, I think seeing young people involved in something like that and also the origin of something like that is a huge inspiration, what is possible. I think in our societies, maybe especially in our Western societies, we sometimes find ourselves thinking we can't do a lot or we can't change the system or something like that. And this idea from the South Pacific was an idea, do something within the system that maybe hasn't been done before. And that's it's a huge inspiration for me. Seeing how the Pacific invited people from other regions to the table and was very, very much supportive. And the leadership of Vanuatu really stood out. What they have done during the proceedings and just before the oral hearings is just amazing.
And I also asked Valentina to ask him how he actually wants to make the kind of mind-numbingly boring bits of this very legal case at the ICJ, which is it's interesting for legal nerds like us, but how do you make kind of the Great Hall of Justice and all the legal minutiae interesting for a bigger public?
Yeah, first of all, law might be not the most entertaining thing in the world, at least for a broader audience. Speaking here as a non-lawyer, I think law doesn't make sense if there are no people behind who want rules for our society and justice for our society. And yes, it's sometimes difficult for a broader audience to make that accessible or easy to understand. But at the end, I think we all know or have a feeling or a compass what is right or wrong, and I trust in that with this documentary. And this is beyond articles or paragraphs. Yeah, it's a huge challenge, and it's really a process of months and months to even go down to word-by-word transcripts of proceedings and events and so on, and try to combine different scenes that a broader audience or helps a broader audience to understand what's going on and helps to understand the context of all of that. But it's a really tiring work. More or less you need to be crazy to do something like that. But I think it's worth it. The story deserves it.
So I'm really looking forward to that movie, and sure I'll try and catch up with some of the others that I know that have been made around this when they come out, and how exactly they translate those issues into this visual format.
After the hearings on December, I tried to get some information from everybody while it was still fresh and managed to nab some experts about what they saw in terms of the actual arguments made and how to look at what we heard and to guide us through what states were arguing and the different approaches they took. I spoke to Nikki Reisch, who's the director of the Climate and Energy Program at the Center for International Environmental Law. And this interview goes on a bit, but I think it's interesting that we get all the specific little details of the arguments here.
So first, just to underscore the picture you painted, really what we saw emerge over these 2 weeks were two very distinct positions. That of the majority of the world, who argued here before the majority of the countries here, who argued before this court that states have long-standing obligations under multiple sources of international law to prevent harm to the climate system, and that their conduct of major polluters over the course of many years that has led to the climate crisis we are facing and brought the world really to the brink of extinction, that conduct is in violation of those duties and has been and is still in violation of those duties, and that the violation of those obligations under human rights law, under longstanding customary international law, under the law of the sea, and under the climate treaties triggers legal obligations to provide remedy and reparation for climate harm. So on the one hand, you have the majority of countries arguing that. And on the other hand, you have a handful of big polluters who have consistently shown their desire to dilute and evade legal responsibility and accountability, and their attempts to sweep history and historical conduct under the rug and tell this court that their legal obligations to address the climate crisis are only what is laid out in the climate treaties, and that when they look at those treaties, they read them as requiring very little more than procedural obligations and voluntary promises. And they say that one should not look at the decades of polluting conduct to date or the legal responsibility for the escalating harms around the world. So those are the two sort of positions that have been laid out in the course of these 2 weeks.
One of the things we've talked about before was that this is not something that the kind of those states tend to say out loud. So how important is it that they kind of have their position on the record here?
I think that's been one of the critical contributions of this proceeding. This has really been a watershed moment already, even before the opinion comes out, because we've not only had a very poignant and powerful representation of the stakes of this crisis, had country after country present that this is a human rights issue. It's a matter of survival. This is not about abstract legal concepts. This is about real lives on the line and about the futures of entire countries and communities on the one hand, but it's also laid bare the positions of the big polluters and those that with an entrenched interest in the fossil fuel economy. And it's forced them to say out loud, the quiet parts out loud, as you say, or to show their legal sleights of hand in the full light of this courtroom and under the scrutiny of not just the judges, but the world, things that are often hidden behind closed doors in negotiations. And by that, I mean the legal loopholes that countries have sought to build into the Paris Agreement and into the UNFCCC to weaken the language of those agreements, to make it harder to hold big polluters accountable for their climate destructive conduct. And we've seen them try to reap the fruits of those labors of years of watering down the negotiated text, and then turning around and saying, oh, it's those watered down texts that contain the sum total of our agreements here. So forcing big polluters to actually come clean with and say in public those legal positions has been very revelatory, and I think makes it that much harder for them to defend their positions. I think importantly, we've seen that the countries that are literally physically losing ground to the climate crisis not only have the moral high ground, but the legal high ground, because their arguments are just much more solid. They've made clear that this is about fundamental principles of law and justice that have existed for decades, indeed, and some of them over a century. And that the question and the request to the court is actually a simple one. It is to apply long-standing concepts of where there is a right, there is a remedy, of the duty to do no harm, to cause or allow others to cause harm to the environment of other countries, to enforce those duties, and the duty to protect human rights, to enforce those duties in the context of the climate crisis, and to underscore that they apply, that there is no exemption for greenhouse gas emissions or climate harm, that those duties have applied and continue to apply. So I think that's been very powerful, and it's been not just morally unacceptable, but legally untenable, the position that we've heard from big polluters here. One of the most galling aspects of these hearings has been to see the contrast between the stories that have been so powerfully told by those whose homes are being washed away or who are experiencing the hardship of the climate crisis, to portray the fact you have Tuvalu, for example, yesterday, standing up and talking about how it's facing a threat of erasure. They're having to contemplate digitizing their country, their culture, their government, that this goes to the core of the right to self-determination, the right to survival on the one hand, and then to have the biggest polluters, the former colonial powers who have been exploiting the fossil fuel economy for decades, turn around and say, human rights law doesn't apply actually to this problem of climate change and global greenhouse gas emissions. Human rights law doesn't require us to reduce our emissions, or that human rights law doesn't extend to the extraterritorial impacts of our polluting conduct, is not only morally unacceptable, it is legally untenable. It is just not grounded in law. Human rights law does indeed require states to refrain from and to prevent conduct that foreseeably infringes on human rights, which greenhouse gas emissions and the climate crisis so clearly do. And that includes regulating corporations, and it requires them critically to provide remedy for that harm. When what makes a legal obligation and not a mere aspiration, is that it carries consequences. When it is violated, there are consequences. And it was powerfully articulated today that if the court were to accept the big polluters' arguments, they would be giving those countries a free pass, and they would be allowing them to flout the law and to breach fundamental principles without any consequence, and that would undermine really the rule of law and the critical need for justice and accountability.
Because one of the arguments of the polluters is it's all in the Paris Agreement, but legally, Paris Agreement, there's non-binding clauses, so you have to make these goals, these climate goals, but there's no consequence if you don't meet them.
Well, I would take a step back. I would say, first and foremost, the climate treaties are binding treaties, and they have as their ultimate objective of the United Nations Framework Convention on Climate Change is to prevent dangerous anthropogenic interference in the climate system, to stabilize greenhouse gases at a level that will enable that. And the Paris Agreement, which was adopted within that framework to strengthen its implementation, requires countries to take action necessary to limit warming to 1.5 degrees, to enhance the achievement of that objective of the UN Framework Convention. So it's all too convenient for big polluters to argue that these agreements don't require much and don't require them to actually meet mitigation targets. In fact, in light of their objects and purposes and read correctly as legal instruments, they do indeed require urgent action at the speed and with the ambition required to curb greenhouse gas emissions, which means phasing out fossil fuels. And they also have very clear binding language requiring developed countries to provide finance to pay for mitigation and adaptation in developing countries in the global south that is bearing the brunt of a crisis they didn't create. So there are very clear requirements and binding obligations in those treaties, but they are not the sum total of what's required of states. And it is not sufficient to say we're ticking the boxes of the Paris Agreement or the UNFCCC and therefore don't have to fulfill human rights obligations or longstanding customary obligations to prevent and remedy climate harm. I think it's helpful to sort of break down the approach of the big polluters. What's the strategy here, right? So number one, the strategy has been to say, okay, the questions before the court, the court has been asked by the UN General Assembly to clarify what are the legal obligations of states to protect the climate system and what are the consequences when they fail to uphold those obligations and harm ensues. So the first strategy of big polluters is to say, well, let's narrow the universe of law. You really should only be looking at the climate treaties. Nothing else is relevant. And then to read those treaties as requiring very little at all. And then to say, okay, and if you think anything else applies, any other law applies outside of or before those treaties were enacted, it too is very narrow. And in fact, it didn't speak to greenhouse gas emissions, so it didn't apply at that time. And then to say, because you can't make out a breach of these longstanding obligations, and because we have ticked all the largely procedural boxes of the UN climate treaties, we've cooperated and we've come to talks, that you can't hold us in breach. There's no breach of international law, and therefore you never get to the question of legal consequences or remedy. So this is the kind of stepwise analysis that we've seen the fossil fuel giants roll out here, and that really just fails at every step as a legal matter. And we've seen that powerfully argued in both the written and oral submissions of the majority of countries that have come before the court.
A big demand of the small island nations and a lot of the nations that are affected by climate change is that the court also say something about reparation for harm done. Why is that such an important part of this hearing?
For a number of reasons, not least because the degree of climate harm and devastation escalating around the world demands urgent attention. But it's a question that hasn't really been satisfactorily addressed by other courts, and that is that climate harm can be attributed to the conduct of states over time, and that conduct in violation of international obligations gives rise to a duty, a legal duty to provide remedy and reparation. For too long, the issue of climate reparations has been taboo and has been considered something of charity, that these are mere moral imperatives. But this is an opportunity for the court to underscore that there is a legal obligation on the part of those big polluters whose conduct over decades has breached their duties to provide remedy and reparation for the catastrophic consequences that it has unleashed, and that stems from first principles of law. Where there's a right, there's a remedy, and where there is a wrong, that there's an obligation to first and foremost stop that harmful conduct and to remedy and repair the injury that it causes.
States also argue that it couldn't be traced to them, the damage that was done to small island nations, so the kind of effects are extraterritorial and couldn't be lead back to them, that harm is falls back on them. What is the kind of legal argument to counter that? What are they trying to argue illegally in that sense?
Well, I think we've seen many of the major emitters seek to hide behind the alleged complexity of the problem and to suggest because there are so many actors or countries who've contributed to the climate crisis that none of them can be held individually accountable. If they've repeated the word collective quite a number of times, this is a collective problem. But under longstanding international law, the fact that there are plurality of wrongdoers, multiple countries that have breached their duties or contributed to a harm, doesn't diminish the responsibility that each one has to uphold its duties and the responsibility that it has for repairing the harm to which it's contributed. So that is to say that the fact that there are multiple actors contributing to a wrong doesn't preclude holding each one of them individually accountable for their breaches. And moreover, the issue of extraterritoriality, the fact that states have an obligation under international human rights law to regulate the conduct of private actors, including companies within their jurisdiction and control, that has foreseeable harmful consequences to human rights and the environment, regardless of where those consequences occur. If there is conduct within the control of a state that causes harm beyond its borders, that state is responsible for failing to regulate it, or for, in fact, as has happened for so long, actually aiding and abetting it by funding and authorizing and doubling down on destructive conduct like fossil fuel production and use. So there is both under international human rights law and under fundamental general principles of law, of responsibility of states when they contribute to a harm, even if there are others who do so too, and to be held accountable and remedy that harm. And the science is also on the side of justice in this case. We've heard polluters say that it is not possible to trace harm to their conduct, but in fact, the science is crystal clear. We know this is not a whodunit. We know the causes of the climate crisis, and we know the activities that have generated the greenhouse gas emissions, and we know their consequences. We can calculate the contributions of each state to cumulative greenhouse gas emissions. That history is not irrelevant, as some would have this court believe, and we can show that harm to the climate system has real material and non-material consequences on lives, on cultures, on territories around the world. That science is crystal clear. There is no factual or legal bar to holding individual states accountable for their role in this crisis and their failure to repair the consequences.
We are going to be watching, obviously, to see exactly what the judges say in their advisory opinion. I know that you're going to have to do a very quick take because you're Reuters stuff, but what kinds of things will you be looking for just in that first set of understanding? What are you expecting to hear from the court?
Well, this is one of those cases that builds on these other climate cases we've seen coming out. We've already also spoken in earlier podcasts about the IDLOS ruling, and there is also a very recent ruling from the Inter-American Courts of Human Rights, which is also an advisory opinion on climate change, where they essentially said that member states must cooperate more to tackle climate change, and also specifically said that countries should monitor corporate activities. And so I'm looking for bits that build on that, and of course, whatever they say is going to be interesting because this is the UN's top court. So we've had these kind of regional courts or courts that deal with a specific bit of the law, but the ICJ is supposed to kind of deal with all of international law, which means that it could be cited in cases all around the world. And that's where this is going to be most interesting and influential because, advisory opinions are non-binding, but their effect is really in how they can be used in kind of national legal cases or national climate change litigation where a lawyer could go to, let's say, a court in Chile and says that the government doesn't do enough of this, and here the highest judges of the UN had said that government should really do this. So I think that's going to be interesting. I think because it's the ICJ and they're not super climate scientists, I don't really expect to get kind of numbers or temperatures or threshold values or something like that, but I do expect a kind of general idea about what states should do.
I think we should also point out that today, the day that we're recording this, there's a special meeting in Bogota of a thing called the Hague Group, who are talking about how to implement the advisory opinion on Palestine, which came out a year ago. So I find it interesting also to try to think for ourselves ahead what states will actually be doing, rather than just the activists taking things to court and arguing, but what states themselves will take on and say, okay, now we have to do something in response to this opinion. So I'm wondering myself whether we'll see actually some action, obviously not immediately, but maybe over the next year or couple of years, and it might spur something along.
Possibly. I think there you also have the problem of look at what is happening with international law and which opinions are kind of followed and which aren't, and all these controversial things. Obviously, the advisory opinion on Palestine is considered controversial by some countries, and they're all stressing it's non-binding. And so maybe now to stand up and then really get behind the climate change ruling is also politically not advantageous for them. So, this is all... Maybe that's why I'm focusing on these national courts, because even if governments have political reasons to back some opinions and not others, sometimes courts kind of correct that, and governments need to be taken to court to keep to certain legal obligations that other judges have said they had. So maybe that's why I focus on that.
Well, I'd say that's right in the centre of what we try and cover. So yes, let's keep on trying to cover the courts and ask those questions. Look forward to seeing you after this opinion.
We'll see how this opinion comes out. And one thing I can say, I can lift a little bit of the veil, and I've heard that it's a very long opinion and that it's, I believe, 500 pages. So I don't know how they're going to condense that, but I'm expecting it to be a long reading. Usually these ICJ rulings, they read out a summary and they try to get it done within 45 minutes or an hour. I think we're going to be there for a little while longer.
This was Asymmetrical Haircuts, your international justice podcast, created and presented by Janet Anderson and Stephanie Vandenberg. This episode was created in partnership with justiceinfo.net, an independent site covering justice efforts for mass violence, and with the Hague Humanity Hub. Music is by autonautics.com. You can find show notes and everything about the podcast on asymmetricalhaircuts.com. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.